what they want to. I don't know what they say. They want to stop the implementation, but the bill is already being implemented. I don't know what they mean by that. Upon the assent of the president, a bill, if Parliament has not postponed the operation of the bill, immediately after the assent, it comes into operation. So if you fall foul to it, you can be prosecuted for falling foul to a bill that has been assented by the president. So this bill is in operation. The necessary structures are being put in place now. It doesn't mean that it's not being implemented. It's being implemented. If the minister tells you that the actual collection will start from 1st April, 1st May, and you think that it's not started, so you want to put impediments in the way before the commencement date. I don't know what the understanding of the commencement or the implementation of the bill is. So that is it. But I think that the other matter that has come up strongly is in respect of the vote taking on the e-levy. And our colleagues are saying that they've taken the matter to Supreme Court for the Supreme Court to rule about the supposed unconstitutionality of the vote that was taken on the e-levy. Well, I'll just say that the burden of proof lies on the minority to go to court and prove their case. The Supreme Court, I'm sure, no Supreme Court anywhere, indulges in processes and procedures relating to Parliament. It's the reason why when they took a vote on the supposed rejection of the budget statement and economic policy, you know what they did? I'm sure you know what they did. They pushed for a division. And the division, they recorded the numbers. The speaker put the question, those for say aye.
0.
So the votes and proceedings the following, they captured it. Those for the approval of the motion, the adoption of the motion to approve the budget statement and economic policy, 0. Those against, 137. Abstentions, 0. Go and check the votes and proceedings the following day. What does it mean? They push themselves into a labyrinth, right? So now thereafter, we heard that that is when we went on recess. It's come to light that the same minority chief whip had filed a motion of rescission on that statement that the speaker read out. Again, I don't see where his strength is. A motion of rescission. What are you rescinding? A motion of rescission, as contained in our orders, provides that you can rescind a decision of the House, right? A firm decision has been arrived at on the subject matter, but maybe upon reflection, it is seen that what Parliament did was wrong. So we come with a motion of rescission to rescind that decision of the House. What the Speaker did that day, if you heard him, and I believe most of you were there, what did the Speaker tell us? We got to the point where we have communication by the Speaker. So the Speaker, before reading that testament, said that he was coming by communication by the speaker to give some information. So it is, what he did is communication from, or if you like, by the speaker. How do you come by a motion of rescission? A person gives you information, I'm rescinding the information that you have given. It has no place in our procedure. It's a dangerous thing that he's doing. Why? If a motion of rescission can be granted on a communication, not even a ruling from the speaker, because that was no ruling. If a motion for rescission can be granted space relating to mere communication from the speaker, then we could have a situation where the president communicates to Parliament, and the next day somebody rises up to say that let's have a motion of rescission to the information that the president has provided us. I don't see where his strength is coming from. And I thought that really, on the face of it, is farcical and is strange to our rules of procedure. Now,
Order 76, and with your permission, I read. 76.1. Every application to Parliament shall, and I think the word there is shall, be in the form of a petition. And every petition must be presented by a member of Parliament, who shall be responsible for the observance of the rules contained in Appendix A. Mr. Speaker, I heard you said, you yourself alluded to the fact that members of Parliament could raise matter that could be referred to privileges, and civil society could equally do same. Mr. Speaker, with the greatest of respect to your office, I disagree with you vehemently when you, Mr. Speaker, want to do that yourself. Because it has to be a member of Parliament who has to do that according to our rules.
Honourable member, read the standing order again.
Mr. Speaker, we will be careful to listen.
Read the standing order again.
Mr. Speaker, it will be good to listen to me. When I'm done, you have the privilege to make your
Minority Chief Whip.
Mr. Speaker, you have to first
read the standing orders again.
Mr. Speaker, I have read what I want to read, and I've stopped where I want to stop.
Honourable member,
you listen to me, and when you hear me,
will you resume your seat?
You have to hear me first.
Will you resume your seat?
Mr. Speaker, you have to hear me first.
Will you resume your seat?
Mr. Speaker, we heard you in silence. Please, no, leader, no. Mr. Speaker, we heard you in silence. Mr. Speaker, it is only fair that you hear us, and when we are done, after the ruling and the decision to be taken, Mr. Speaker, is absolutely yours. But to listen to us, Mr. Speaker, you must listen to us. And Mr. Speaker, when you are making reference to the ruling of the appeals court, Mr. Speaker, the interesting thing that you left out, and I draw your attention to this, is that when that appeals court made that ruling, it concluded with this. After the court has said that the seat will be declared automatically, it went ahead to say that under the 1992 Constitution, however, it is the High Court which can declare a member of Parliament seats as vacant without providing any reasons or legal basis for the assertion. More particularly, when the provisions in question do not either expressly or impliedly rope in the High Court. This is what the appeals court did. So, Mr. Speaker, with the greatest of respect, we agree you made a statement, but your conclusion, Mr. Speaker, the danger, colleagues, as we sit in this chamber, is this. If we allow speakers to take petition from outsiders, and so motu with petition from outsiders to refer members of Parliament to privileges, colleagues, will be doing ourselves the greatest disservice. Because we will one day get a dictator speaker who will simply take statements from outsiders and begin to penalize individual members of parliament. It is